The Supreme Court will hear oral arguments Wednesday in two cases over a regulation that forced herring fishermen to foot the bill for government-mandated monitors, but the minor dispute could have profound consequences, as justices consider whether to overturn a 40-year-old landmark ruling that governs how federal agencies operate. The court will hear oral arguments Wednesday and will issue a ruling likely in a few months, sometime before its term ends in June. It's still unclear how the 6-3 conservative court could rule, though at least two justices have signaled they want Chevron to be overturned. Justice Neil Gorsuch wrote in a 2022 dissent he believed the ruling deserves a tombstone, while Justice Clarence Thomas wrote in 2020 that Chevron is in serious tension with the Constitution, the Administrative Procedure Act, and over 100 years of judicial decisions. The cases being heard Wednesday are the culmination of a long effort by judicial advocates on the right, who favor smaller government and giving more power to conservative-leaning judges and justices, to get justices to reconsider Chevron. Noting the ruling is now anathema to many in the conservative legal movement, ProPublica reported in September that the Koch network, backed by billionaire Charles Koch, held an internal meeting in 2022 to double down on its strategy to get the Supreme Court to overturn Chevron. The group reportedly emphasized the need to find cases that could be a vehicle for overturning the precedent, after already repeatedly challenging the ruling in court and funneling money to law professors that oppose it. The firm representing the fishermen, cause of action, has received millions from Koch's group Stand Together, The New York Times reported, based on tax filings, and the attorneys representing the fisheries work for the Koch-funded Americans for Prosperity. Left-leaning watchdog group Accountable U.S. has urged Gorsuch to recuse himself from the cases being heard Wednesday because of his ties to oil industry billionaire Philip Anschutz, who the group argues stands to profit from a ruling that overturns Chevron. Gorsuch has a number of close ties to the billionaire, as the now justice represented Anschutz and his company when he was a lawyer. During the George W. Bush administration, Anschutz recommended Gorsuch be appointed to the 10th Circuit Court of Appeals, and the justice has frequently attended the billionaire's private retreats. Gorsuch has a conflict of interest in the Relentless and Loper Bright cases as a result, Accountable U.S. argues, because the widespread weakening of regulation could benefit Anschutz's company, which has fought Chevron and federal regulations in the past.